Hello, and you're very welcome to episode 45 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisis.ie.
Mark, I really enjoyed the interview last week with Andrea Carter. Listeners will recall she gave up the practicalities of law both as a solicitor and a barrister to become a full-time writer with her series of novels about solicitor turned super sleuth Benedicta O'Keeffe, or Ben O'Keeffe. Fantastic interview.
Yeah, she's really interesting.
And she had a great backstory. She moved from the Midlands up to Inishowen and practiced as a solicitor in Carndunna. I think it was you who said next stop Iceland, and then came to Dublin and practiced as a barrister and now has become a superb novelist.
Yeah, and very successful.
And her most recent book is Death Rights, I believe.
That's right.
And the original one was Death at Whitewater Church.
That's right. And I think there have been about 5 between the two.
5, yeah. So fair play to her. We're giving a huge recommendation. Excellent work, and love that interview. Okay, well today, Mark, myself and your good self are going to engage in a little bit of navel gazing as we welcome to the studio Niamh Howlin, Associate Professor of Law at UCD, who is just about to publish her book on the history of barristers in Ireland. I think this is going to be a publishing sensation, Mark. I mean, surely they'll be queuing around the corners.
Barristers, yeah.
Harry Potter-esque, will it be? No, really looking forward to this interview. We've had a sneak preview. She has put in a big shift researching this book, hasn't she? You were commenting on the number of footnotes. Yeah. Incredible.
Yeah, and interviewed a huge number of barristers, and yeah, you should really put the legwork in.
No, it's really good. So really looking forward to this interview. Okay, Mark, so let's go to some cases from the Decisis website. Our first case today is a very interesting case which made headlines recently. This concerned a school principal who had been suspended from his position as principal of a newly founded Gaelscoil in Gorey, County Wexford in 2009. It's a case of An Bord Bainisteachta and another versus the Labour Court, and this is a decision of Mr. Justice Cregan.
Yeah, well, in fact, there's 2 judgments here, which I think it's just interesting to see the 2 of them. What is extraordinary about this case is that the disciplinary process started back in 2009 following what they described as a single child incident. That was clearly an incident, and there was a complaint against this particular school principal. He had been the founding principal of the school. It was a Gaelscoil that had been founded on non-denominational lines, so, very forward-thinking, modern Gaelscoil. And the matter went through I suppose what was then the Employment Appeals Tribunal, what's now the Workplace Relations Commission. And eventually it came as far as the High Court, where the school basically complained that the Labour Court had made the wrong decision in saying that he had been wrongfully dismissed. The Board of Management disciplinary panel had been motivated by animus.
And a vendetta.
Yeah, well, that came into the second judgment. So first of all, they found that he'd been wrongfully dismissed. And then what they had to decide then was what the implications were. And because he'd been suspended since 2009, another school principal was already in place who was running the school. And so they had to determine, well, what happens? Do they replace the principal who's been in place for so long? And Mr. Justice Cregan said yes, because the Board of Management had been motivated by a vendetta that clearly everything had been done wrong, effectively. He said that the principal had to be reinstated.
So it is now a school with 2 principals.
2 principals. Was
it's a bit like the 2 popes all those years ago back in Avignon.
Difficult to know what consequences can arise from that, but that's what's being determined in
this
case.
Is a very serious case. And I mean, obviously, 2009, it took a long time before kind of a conclusion was reached in this case in the High Court. There is a suggestion that this decision is being appealed.
You would wonder how many appeals can be gone through. I mean, what Mr. Justice Cregan said here is the Board of Management has had 3 bites of the cherry at the WRC, the Labour Court and the High Court. It has failed in all 3, resulting in significant cost for the school. And then it says it now wishes to have a 4th bite of the cherry. I have no doubt at all that the Board of Management's case can be properly characterised as a vendetta. I think it's extraordinary language.
And he awarded costs to the principal concerned.
Yeah.
Okay, so that kind of covers 2 cases today. Let's go. Our final case is a European Arrest Warrant case. And this concerned a prisoner who was due to be released at the end of a life sentence. But he was then arrested under a European Arrest Warrant for surrender to Portugal in relation to a conviction in absentia back in 2009, while he was already in Mountjoy. This is the case of the Minister for Equality versus Wade, and it's a decision in the High Court of Mr. Justice Carida Naidu. Yeah.
So the sequence here is interesting. This particular offender was serving a life sentence for a murder that had been carried out in 2005. He was convicted in 2007. So he had a life sentence ahead of him. In 2009, he is served with notice of not, in fact, a murder charge, but an aggravated burglary charge in Portugal. And he does nothing about it, presumably thinking, I have more things to worry about at this stage. Fast forward 13 years to when he is either about to be released, or certainly release is not that far off. And he is arrested under a European arrest warrant for surrender to Portugal, where he was convicted in absentia back in 2009 on the charge of aggravated burglary. And so the question...
Sorry, I incorrectly said murder.
So what Mr. Justice Naidu had to decide was there anything unfair? And was there any reason not to surrender him to Portugal? And although trials in absentia are extremely rare in Ireland, they are a reasonably common feature of the civil law system. And under the European Arrest Warrant regime, providing that you have had adequate notice of the trial, a trial in absentia is not of itself considered to be unfair.
I'm thinking of Ian Bailey, actually, in France. Wasn't there a full trial for murder for him in Paris? And obviously he was in absentia. He didn't go to France.
Yeah. Well, I think in this particular case, the issue was that if the person in this case had instructed a legal team either in Ireland or in Portugal back in 2009, he would have been in a position to engage with the trial. But the fact was he was on notice of the trial and he didn't participate in any respect. And so he had to face the consequences. So having completed his sentence in Ireland, he now has to face another, I think it's 2 years and 4 months imprisonment in Portugal.
Okay, all right, very well explained. We're going to be back shortly with Associate Professor Niamh Howlin.
Silence in the Fifth Court.
Okay, I am delighted to welcome to the studio Niamh Howlin, who's an Associate Professor of Law at UCD. But you're in here wearing a different hat, Niamh. You are an author, and your book called Barristers in Ireland, An Evolving Profession Since 1921 is due to come out on the 12th of this month. So thank you so much for coming in and talking to us about it and giving everybody a sneak preview. This is very exciting from myself and Mark's point of view. A history of the barrister's profession in Ireland, Mark.
Yeah, the profession that's unwilling to change.
Yeah, wow. I'm sure there must be a car chase on every page. Okay, Niamh, will you tell us about the book and why you decided to write this book?
First of all, thanks very much for having me. It's a pleasure to be here, and I've listened to many episodes of the podcast, so it's lovely to be here to see where it all happens.
Thank you very much.
So originally I was approached by James O'Reilly SC, who's on the Library Committee of the King's Inns, and he said that there was an interest in having a 20th century history of the bar written. We have some fantastic scholarship already on the history of the King's Inns. Colm Kenny has written a lot on that. And people like Dara Hogan have written about the history of barristers and solicitors up until the 1920s. So the idea with this book is to pick up the thread in the 20s and bring it right up to the end of the 20th century. So 1921 is the start date. That was the first time we had women called to the bar. And it was the first call date since partition. So it was a time of a lot of change. And then the end date is the end of the 1990s, which was also a time of change in terms of the composition of the bar. So there were a lot more women at that stage. Technology had changed at the bar, practice areas, the physical infrastructure of the law library. So that was a time of a lot of change as well.
Okay.
So those bookend the project.
And I noticed on the front cover of the book, you have two of the early women barristers. Avril Deverell, Mark spotted her from a country mile straight away. And the other, her colleague, I can't remember.
Frances Kyle.
Frances Kyle, that's it. And why did you put the two women on the front of the book?
Well, they were the first two women called to the bar in Ireland. And in fact, the first women called to the bar anywhere in England, Ireland and Wales at that time. And the cover image is actually from a portrait that was commissioned by the Bar Council and the King's Inns a couple of years ago, and which now hangs proudly in the King's Inns. And it was done by an artist called Emma Stroud. And it's part of the Bar Council and the King's Inns In Plain Sight campaign, which is an initiative to get more pictures of women lawyers and women judges on the walls of the King's Inns.
Okay, fantastic. And so your starting point really is the foundation of the state and how the law library moved into the new state. And was that an easy move, or did some of them still believe that they were beholden to a parliament all the way across in the UK, in Westminster, or were they able to happily make their peace with the free state and develop accordingly?
I would say that the bar were fairly adaptable in the 1920s. There was a huge amount of change at the time, and I'm sure there were a multiplicity of opinions about the way things were going, but generally, as a whole, as a profession, the bar went with it. And we see members of the bar being really involved in creating the architecture of the new state. You know, they were drafting the constitution, they were drafting the Courts of Justice Act, they were populating the bench, they were in the civil service, they were everywhere. So I would say that the bar really embraced the new legal order.
Can I go back just even a little bit before independence? Because I think what's fascinating, and you cover it a little bit in your book, is the Dáil courts, which I don't know, I mean, we could obviously do an entire episode on this, but basically during the War of Independence, an entire parallel court system was set up, particularly outside of Dublin, which had barristers kind of organising it, and yet the Bar of Ireland determined it was professional misconduct for a barrister to appear before one of these courts. But it was quite a sophisticated court system, I think, wasn't it?
Yeah, there were some barristers involved in litigation in the Dáil courts. And then when the Dáil courts were put on a more official footing, I suppose, members of the Dáil Supreme Court and the Dáil Circuit Court were drawn from members of the bar. So I suppose the opinions of members of the legal profession definitely varied in relation to these courts.
And yet, once the Free State came into being, by and large, the profession managed to come back together again and respect the newly established courts. I mean, the anti-treaty side didn't keep Dáil courts or an equivalent going for any length of time, did they?
Yeah, I would say that from the time of the Courts Act 1924, everything ran very, very smoothly.
Which was quite an achievement of following a bitter civil war.
It was remarkable, yeah.
Okay, so let's talk about how the profession sort of evolved then in the Free State. Like, it was compact and bijou, really, wasn't there? Wasn't too many barristers in those days. It was quite nice. If you were part of the circle, you were kind of doing okay, weren't you?
Yeah, I think compact and bijou was a lovely description, actually. I wish I had thought of that when I was writing. It was a small bar at the outset, and people tended to come from very similar backgrounds at that stage, and people knew each other. So it was cosy, I would say, yeah.
Yeah, okay. And who were the stars of the early bar? Let's go back to the 20s, 30s, 40s. Maybe that's unfair. I'm thinking of Kingsmill Moore and his, fly fishing in the rivers and lakes of Ireland and people like that. When I think back, I think people like that were characters. Okay, let's talk about how it sort of evolved, Niamh. So let's big developments in the bar in terms of the evolution of the bar. When did things start to change, or was there any noticeable change at any stage?
What I would say, based on my own research, is that there were always little changes happening. And I think there is just a continual evolution in the bar. And practice changes, practice areas change, the composition of the profession changes. They're not always massive seismic changes, but they're happening all the time. And if we look at the way that the bar operated and the way it was constituted in 1921, it was very different in 1999. But I don't think you can point to one single, major change. But there are certain things here and there. So things like the introduction of legal aid, for example, changed the way that a lot of people practiced. Practice areas in the circuits tended to die out and new practice areas evolved. And the idea of travelling around the circuit together as a group and all staying in the same hotel and having dinners every night changed by the end of the 1990s.
Okay, and do you think it has become a profession that reflects the society of Ireland? I mean, if we look at, for example, the guards, once upon a time you had to be over 5'10" or 6 foot or whatever, and now we have all sizes and shapes reflecting the Irish society in which we live. Is the bar like that? Does it reflect all aspects of Irish society? Do you think it has moved? It's certainly progressed. But do you think that it is reflective in that regard?
Well, I suppose I should preface my remarks by saying, first of all, I'm an outsider because I'm not a barrister. And secondly, I've been looking at this through a historical lens. I don't know anything about what happened from 2000. I mean, I joke, but I don't know if I'm qualified to make an authoritative statement. But I will say that the bar certainly seems to be moving in a very positive direction in terms of inclusivity and diversity and representation.
Okay, very good. And look, your book is fantastic. As I said, we got a sneak preview. It was a PDF copy. It's not like reading you have the proper book in front of me now, and it looks fantastic. I noticed one of your chapters is the gendered bar. Why the gendered bar?
Well, why not the gendered bar, I suppose, to turn it around? So there has been quite a lot of reflection in the last couple of years on the early arrival of women into legal professions. And we've had all the centenaries marked with the solicitor's profession and the barrister's profession and so on. And there's this idea of the famous firsts. First woman at the bar, first woman in the circuit court, first woman on the High Court, and so on. So whilst I think it's really important to celebrate all those achievements and to mark them, I wanted to also look at, apart from those amazing, trailblazers, what about the ordinary lived experiences of everyone else who was at the bar, who was a woman? So I'm trying to look at what it was like to be a woman at the bar at these various stages.
Okay, great. And the chapter I loved, I loved it. I mean, the book is fantastic. But one chapter I really liked was Taking Silk. Mark always says, for our listeners who are lawyers or law students, we have loads of listeners who are non-lawyers and not law students. Taking Silk, what is that? And why was that such a fascinating chapter?
So when we talk about taking silk, we're talking about people being admitted to the inner bar, so becoming a senior counsel or a King's Counsel as they would have been known in the early 20th century. So I interviewed various people about their experiences at the bar and so on, and I've looked at memoirs, and I've also looked at documents that are in the National Archives, in the Attorney General's Office papers and so on. And a few very interesting things have come out of all of that. So first of all, it's very clear that the decision whether or not to take silk was a huge decision for a barrister. And that may still be the case today. It was certainly true in the 20th century. And all of the interviewees that I spoke to for the book said that this was something that they really grappled with, and they really had to think about it because it was such a risk. So, is it worth getting the better work or the more interesting work and stepping away from what's probably a really successful junior barrister career? Now, for most of the 20th century, the procedures for applying to take silk were not really clear to anybody.
Yeah, so it was a bit ad hoc, really, wasn't it?
It was a bit ad hoc. I mean, even the Attorney General and the Chief Justice often didn't know what was supposed to happen in these situations. So, I mean, there are letters of application in the National Archives that are just one line long.
Yes,
where someone writes in and says, I would love to take silk. Yours sincerely.
Think about me. Yeah. Thanks a million.
Yeah. And when the bar was smaller, it would have been easier for the Attorney General and the Chief Justice to know something about the people who were applying to take silk. So it was, it was less necessary maybe to write out credentials and to, submit a curriculum vitae. As things progressed, people did start writing slightly more expansive applications.
I think it's a lot more extensive now, the application process to take silk. But anyway, Mark.
You talk about the people you interviewed. What struck me from looking at your footnotes, which are extraordinarily extensive, I'd have to say, I loved where every so often you'd see a quotation, and underneath it would say B12 or B13. You have a lot of anonymized barristers who clearly spoke very frankly. And in your introduction, you talk about sort of being invited around for cups of tea and what sounded like some conversations hidden away in cafes and that kind of thing. What kind of people were you speaking to, or are you able to expand on that?
So this was one of the most enjoyable parts of researching this book, because I'm a legal historian and usually I just work with paper. But because this is a slightly more modern history, I got to talk to real people, which was, quite a thrill. So I interviewed 29 people on the basis that their anonymity would be ensured so that they could speak frankly. And these were people with different types of practice. So people who had very successful practices, others who had more modest practices at the bar, people who worked mostly on circuit, people who worked in Dublin in the superior courts, men, women, different age groups, different practice specialisations and so on. And many of them had gone on to do other things after the bar, whether that was, being appointed Attorney General or being appointed to the bench.
I think I know who you're talking about now.
So we had some fantastic conversations. I went to people's houses, or I went to their offices, or they came to my office. And yes, there were plenty of cups of tea and coffee and things consumed. I ended up with hours and hours of material, like hundreds and hundreds of pages of transcripts, but obviously it had to be selectively edited.
And because you were dealing with pre-2000, were you specifically aiming to speak to people kind of in their 70s, sort of people who were reasonably long in the tooth? Or?
Well, again, I tried to get a bit of a mix. I don't know if I'd comment on people being long in the tooth.
That's it. Sorry, I'm saying nothing.
But Peter, you don't look your age.
No, not at all. Not at all.
So some of them were called as early as the 1950s and some were called in the 90s, just again to get a broad range of experiences. Because I think someone called in the 60s had a very different experience to someone called in the late 80s or 90s when the numbers at the bar had shot up and so on.
Well, in a previous life, we had a wonderful interview with Frank Clark when he was talking about trying to get his hands on that one telephone in the forecourt. So I think there's a few more telephones down there these days. Niamh, the book is brilliant. It really is brilliant. And I mean, all the chapters, I'm just looking at the headings of some of the chapters here. Obviously, the law library, and you go into that. Networks at the bar, we won't go into that. But barristers' contribution to public life. Now, there's a biggie. Okay, because I often see, let's say somebody's appointed a judge or appointed to a lofty position, and, cases that they're involved in are recited, and they're very important. But sometimes I wonder how the public perceives that. So tell us, barristers' contribution to public life.
Yeah, thanks. So I suppose apart from, engaging in litigation and working in the courts and maybe being appointed to the bench, I found in researching this book that barristers pop up in all areas of public life. They pop up as, broadcasters, and journalists and commentators. They're politicians, elected representatives. They're in government departments. They're, civil servants, working in embassies and so on. And my attempt here is to just capture the range of different experiences or the range of different areas where barristers have a public voice or a public contribution to make. I'd be doubtful whether there's another profession that has been so involved in Irish history over the last, century or so. And I would say that the bar has, I suppose, as a consequence of having representatives and members in all of these fields, I think the bar has been very influential on public life and the development of public policy and foreign affairs over the last while.
And in terms of, let's say, certain positions that are within the realm of the bar, obviously the Attorney General. The Attorney General has always been a barrister. It doesn't have to be a barrister, but it has always been a barrister.
Yeah, all our Attorney Generals have been members of the bar and have been traditionally seen as the leader of the bar. I had some interesting chats with former Attorney Generals in the course of the research for this book, and any that I spoke to said that they had very much enjoyed that experience and had found, sitting at the cabinet table and so on to be just quite a refreshing change from, practicing at the bar.
I mean, a lot of barristers have gone on to become Taoiseach, isn't that right, Mark? I'm just trying to think over the years. Wasn't there, John A. Costello going back to him? Yeah. Charlie Haughey was a barrister.
I think John Bruton was...
Did he do the bar? Did he once upon a time?
Yeah.
But anyway, so they have. They've always stuck their noses into various different other areas. I agree with you, Niamh. And sometimes have made a very important contribution. Certainly. It has to be said. Okay, perceptions of the profession. That's another chapter that you've written. How is the bar perceived by people outside of the profession?
One thing that I found in researching this was that up until a certain point, barristers do seem to have been held in quite high regard in Irish society. And that's probably part of a wider deference for authority and a deference towards, professionals in general. So people respected the Gardaí, the priest, the doctor, the lawyer, and so on. I think from the research and from speaking to people in practice, there probably was a turning point in the 1990s when public perceptions of barristers took, I suppose, a bit of a dip. And I think that would have been around the time of the tribunals.
Of course, yes.
When there would have been, news reports about very high earning individuals and so on, which weren't necessarily representative of the profession as a whole. The idea of how the public view barristers was something that came up in conversations a lot. And I found that the people I interviewed were very conscious of how they were viewed by the public. And one thing that a couple of people said was that people don't always regard the bar very highly until they need to engage the services of a barrister. And then they see the work that we do, and then they respect and, hold us in high esteem, which I thought was quite interesting.
Okay, but there is that desire to be loved. Is that does that exist? It's show business in one way, isn't it?
I suppose it is, and it's such a performative profession. People are so publicly exercising their work and they're on view when they're in court in the way that a surgeon is not on view when he or she is performing surgery. So
yes. So there is huge public display. Mark, sorry, I'm banging on here. Just to continue with that, in terms of, let's say, characters at the bar, now I appreciate you went from the 1920s up onto the 1990s. I mean, the public perception, I would have thought, is that you have barristers are wonderful orators and they have this notion where people go in and command the court and it's very dramatic and Shakespearean language and all that sort of stuff. Is that changing a little bit? Do we have those kind of table-thumping people still, or is it now kind of, keyboard warriors who are putting in these long submissions, I wonder?
Well, a few people that I interviewed did make this point that the growth in written submissions has had a massive impact on the way that barristers, carry out their work and on the performative aspects of that. In terms of, being the loud orator and so on.
But if we were talking about someone like Daniel O'Connell, he wouldn't really have worked if he was kind of handing over a sheaf with 20 sheets in it, and, a 10,000 word submission. That wouldn't have really inspired the public to the same extent. Mark, what do you think?
Well, I think the performance before a jury is obviously a very important part of the barrister's skill set. And I think people like Daniel O'Connell, whose work before a jury was so key to what they did, that it makes such a difference. You're never going to be handing your written submissions into a jury. You need to properly tug at both the mind and the heart when you're doing that kind of work.
Okay, and just to kind of contemporary issues that you might have touched on in your research, Niamh. I mean, the bar is very much kind of focused on the fact that barristers should remain as sole traders and not come together and join with chambers. From your research, especially from barristers who've seen it all, been there, done that, what do you think? Would they view the way we do it here as the best way to do it, or what do they think about chambers, like our friends across the channel, or the Irish Sea, I should say? I
think overall there is quite an attachment to the way things are done. I think there is an attachment to the communal law library with the sole traders, and this idea that you can, as a junior member of the bar, you can rub shoulders with the most senior person, you can ask them for advice and so on. Now, certainly some of those who were interviewed lamented the demise of, the one communal law library space. And, even though all the fantastic new facilities that were built in the 1990s were very much needed at that point, there is a sense that maybe the library lost something in that. Certainly at different points from the 70s onwards, there were individuals who wanted to come together, who wanted to set up offices or chambers. And this was considered to be very threatening to other members of the bar. And I think the Bar Council was very wary of allowing that sort of thing to happen. So there's a bit of tension, certainly, like looking through the minutes of the Bar Council, there's certainly tension at different stages. And then when people did at certain points go off on solo runs, or where groups of people went off and took offices together, it caused a little bit of bad feeling at times. But again, I think people got over it.
Can I just bring you back to the 1920s? Because one of the things that struck me was what I think you described as the frosty relationship between the Bar of Ireland and the Bar of Northern Ireland. That basically an exemption was given to Kevin O'Higgins to be called to the bar without having to sit his exams or without having to attend lectures. And that was just too much for the Northern Irish barristers. And basically the barristers north and south went their own way after that. I think you were really only looking at the 26 counties, weren't you, in this book? But were you able to compare it all with the practice in the north?
Well, to be honest, a fantastic book about the 20th century history of the Northern Ireland Bar and Inn of Court was published by the late Tony Hart and about 10 or so years ago. And that's a really excellent book, not just about the Northern Ireland Bar, but also he goes into a lot of detail about that breakdown between the two bars and, looks quite closely at the various incidents, like the granting of exemptions to Kevin O'Higgins and a few other individuals as well. I think there were a few other factors as well. I mean, within a few years of the establishment of the separate states, it was becoming increasingly obvious that there were different legislative regimes in both jurisdictions, which was a practical barrier for people who wished to practice in both jurisdictions. And in the mid-1920s, Chief Justice Hugh Kennedy was making noises about making the Irish language compulsory for practicing at the bar. And this was something that really didn't go down well with those in the 6 counties. So there were a few factors, I think, that ultimately led to this like complete and utter breakdown of official relations between the two bars. And it was almost 50 years before there was any coming back together of the two bars. In the interim, there were informal get-togethers, the bar golfing societies.
We definitely play golf, all right, absolutely.
and the Irish Legal History Society.
Of course.
Yeah, very good.
Nice to give them a mention.
Exactly. Niamh, you've talked about the fact, and you're not really a million miles away, but you've talked about the fact that you were an outsider. You're a legal historian and a brilliant legal historian at that. And this meant you had to come within the realm of the bar, and you had to spend a lot of time with barristers. 29 people, is that what you said? You interviewed, and, so you got up close and personal with a lot of barristers and with the law library and all of that to do with the bar. 2 questions. A, did you like your barrister colleagues that you dealt with? Is your fondness for the bar growing? And B, was there anything surprising you learned the closer you got?
Good questions. Well, I have to say I really enjoyed speaking to the 29 people who were interviewed. And, they were all very different people. And I had fantastic conversations with all of them. And they were really, really forthcoming and really honest about their experiences, good and bad. And people really opened up about what it was like for them at the bar. So that was very enjoyable. And apart from that, anyone that I've had dealings with from the King's Inns, from the Bar Council, other members of the bar have been extremely helpful and supportive and interested in this project. So that's been a real pleasure, actually. There were very many stories which just could never be put into print, into the book, which were very entertaining for me, but it's a pity that they couldn't go any further.
Well, you'll have to tell us those afterwards.
When we're off air.
Can I just, will you tell us about the launch of the book? It's October 12th. Where is it being launched and who's launching it?
So it's going to be launched by the Attorney General, Mr. Rossa Fanning, Senior Counsel, who's also an adjunct professor at UCD Sutherland School of Law. And it's going to be launched in the Distillery building on Church Street. Okay,
fantastic. Well, look, every success with the book. As I said, you've brought in the hard copy here today. It looks fantastic. It's a substantial piece of work. It's a hugely substantial piece of work, Mark, isn't it? You were commenting on the footnotes.
Oh, extraordinary bibliography. I mean, it goes on for pages.
Absolutely wonderful. So a lot of work went into it. Can we ask you our final question? Can you recommend any other book? Is there any other book or movie that occurs to you? I don't think I asked you this beforehand.
No.
But maybe from previous shows.
Yeah, I should have had this prepared on the spot. I will say that I've very much enjoyed recently a book by Patrick Radden Keefe.
Oh, yes.
Called Empire of Pain. And it's about the Sackler dynasty. I hope no one else has already recommended this on the podcast.
No, not at all.
It's a fantastic read. Very carefully researched, very carefully put together. He's very open about his sources and so on.
Was it?
OxyContin.
Oh, OxyContin. Yeah, sorry. Okay, yeah.
And he's writing, he's got a law background, but he really gets into the story of the family and the individuals. And it's nearly as good as a soap opera in places. The writing is superb. So
okay,
definitely
what a wonderful
good read,
recommendation.
But not a light read.
Okay, well, Niamh Howlin, Associate Professor of Law at UCD, thank you so much for coming in and being a guest on the Fifth Court.
Thank you very much.
The Fifth Court will adjourn until next week.
So that's all from this edition of the Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest today, Associate Professor Niamh Howlin, who has written a brilliant book about barristers in Ireland. The big launch is on the 12th of October, folks. Get to the Distillery building on Church Street and it's going to be wonderful. It's a wonderful piece of work, Mark. Really is, isn't it?
It is. It's a great book.
Yeah. And loads of research has been put into it and great yarns. Though she says some of the better yarns she had to leave out, unfortunately.
That was very sad.
Anyway, there you go. So before we go, we'd like to say a big thank you to our producer, Conal O'Moroyne, and to the Dublin South Studios for their wonderful work in recording this show, in particular, Mr. Lee Brennan. So for me, Peter Leonard.
And myself, Mark Tottenham.
Thank you for listening, and we'll see you soon in the Fifth Court.